There we go. Someone's going to give me shit for that later. Alright. The applicant, Teal Cedar, applies for a stay of execution of an order of a judge made on September 28th, 2021, ending the interim extension of an interlocutory injunction. Held. Application granted. Applying the three-part test set out in RJR McDonald v. Canada, the applicant has established there is some merit to the appeal. The applicant will suffer irreparable harm if a stay is not granted, and the balance of convenience favors the granting of a stay. Pending judgment on the application for leave to appeal and the appeal, which will be heard together on an expedited basis, there will be a stay of execution of the judge's order. So, later on, we're going to get into this three-part test set at an RJR McDonald v. Canada. Yeah, done some reading, and I've got the actual, I guess, definition of the three-part test from this court case, RJR v. Canada, and we're going to touch on that later. Okay, Stromberg-Stein. Facts. To those on Instagram, you can jump on Twitch. The link is in my bio if you want to see my screen and see the appeal, the written appeal as I go through it. Otherwise, this is what you're going to see. It is not the full experience. I promise you. Okay, Section 1. The applicant, Teal Cedar Products, is a logging company. Facts. Its operations on Vancouver Island, which include an area with old-growth forest, have been disrupted by protests. The respondents include both protesters and interested or concerned parties. I would not disagree with that. I'm just going to throw something different on for background music. Just give me a second. Okay. Section 2. In April 2021, Justice Verhoeven issued an interlocutory injunction prohibiting the respondents and anyone having knowledge of the order from interfering with the use of the roads, the construction, or the timber harvesting activities in, effectively, Teal Cedar's forest tenure. It also authorized the RCMP to arrest and remove persons contravening the order. The injunction was set to expire at midnight on September 26, 2021. Yeah, nothing really to dispute or of note in here. These are just facts. Section 3. The RCMP began to enforce the injunction in May 2021 using methods including exclusion zones, checkpoints, searches, and security gates. Most of the protesting was peaceful and legal. However, some protesters engaged in destructive and unlawful methods of protest. At the same time, while most of the RCMP enforcement was respectful and peaceful, some involved use of force. So here we go. This is kind of where, it was just facts before. Now it's like, I think we could all disagree with some of this. One of the more interesting ones is this. Exclusion zones, checkpoints, searches, and security gates. Something we learned during the court case is that Teal Cedar was urged to apply with urgency for permits to install those gates that we know now on these logging roads in TFL 46. And they did, at the RCMP's encouragement. So the RCMP isn't actually the one using security gates. The only security gate I can think of for them is the one on Kaikus. Yeah. At the beginning of Kaikus, just off Lake Cowichan. I don't even know if it's still there anymore. It is the one where there's a really terrible video where they don't allow like a bus full of Nechalathotep women to go back to their territory. Pretty terrible. Anyways, that's the only time that I can think of an RCMP security gate. The rest have all actually been Teal Jones. Yeah, searches also not lawful. If you can comply with a search, but they have no um, like legal basis to. And what's his name? What's his name? Thompson, Judge Thompson, even said in one of his decisions was that they didn't supply enough evidence to justify the preemptive like enforcement. So preventing people's entry to the area and searching vehicles, he found they had no basis for it, no legal basis. Exclusion zones we already know are unlawful. Checkpoints, again, this is like constitutional freedom of movement kind of stuff. Like, yeah. Like, people should be more upset about that. Like, I feel like everything in there is kind of like worth talking about. Um, this is another line. Most of the protesting was peaceful and legal. However, some protesters engaged in destructive and unlawful methods of protest. It kind of doesn't really make sense because most of the protesting was peaceful and legal. It's like, no, like all of it was illegal. Like, people kind of need to understand that you're out there blocking a road, you are doing something illegal. And there's no real definition of what a peaceful protest is. So yeah, to make up this line between lawful and unlawful and peaceful and destructive without giving like a clear definition of it, I think like he obviously can't, or she obviously. Oh, sorry, Judge. Um, if she were to define clearly what in her mind was considered legal and what was considered illegal, what was considered peaceful and what was destructive, that'd be a pretty big precedent. Um, and I mean, it's not. This is an appeal, not really like a full decision. So I don't know what. I don't know if you can even set precedent on an appeal. Um, it's just one of those things. Like, it's all legal. It's all peaceful. It's all nonviolent. So yeah, I really do like this whole first two sentences. I just like it's kind of BS once you look at it. And then the last one. At the same time, while most of the RCMP enforcement was respectful and peaceable, some involved use of force. Like, I was going to say what I said last time was some involved use of force. Some could be, I think she says it later in here, like the majority or something. We're okay. And it's like, some could be like 49%, you know, or 51%. And I would like accept that as, you know, reasonable. But I think we've all seen force there on a pretty regular basis. I'm not saying there haven't been days that were really quiet. We've all seen those too. But yeah, to say that most RCMP enforcement was respectful and peaceable is like I might accept that if it was like 50.1% of RCMP enforcement was respectful. That's as much of an olive branch I would give her on that. And like I say that from being there. Not all the time, but being there a lot of the time. Okay, section 4. In July 2021, for those of you on Instagram, I am live on Twitch, and I'm recording this so you guys will be able to watch it later. I'm going through the appeal again. Section 4. In July 2021, after hundreds of arrests related to the contravention of the injunction, Justice Thompson invited the British Columbia Prosecution Service to review the evidence relating to the actions of the alleged contemptors and assume conduct of contempt proceedings. The British Columbia Prosecution Service accepted. Yeah. Straightforward. Nothing really of note for us there. Section 5. Following a hearing in July 2021, Justice Thompson concluded some of the RCMP's actions were unlawful and varied the injunction order by adding a direction intended to control interference by the RCMP with work of journalists. Following a hearing in 2021, Justice Thompson concluded some of the RCMP's actions were unlawful and varied the injunction order by adding a direction intended to control interference by the RCMP with the work of journalists. Yeah, he added that, and I mean, I remember the next day, me and Aura had great access. It was fantastic. I told him, I finally feel like I could do my job. But then, like, that same morning is when I got arrested for the second time for being behind their line when I was already allowed to be behind their line. It's preposterous. Yeah. Section 6. On September 17, 2021, following a hearing on the application of Teal Cedar to extend the injunction for 12 months, Justice Thompson ordered the injunction, as modified in July 2021, remain in place until further order. In an order given on September 28, 2021, he ruled this interim extension order would end at 4 p.m. the same day. Despite finding... yeah, that's just like facts and dates and times and what happened. There's not a lot to discuss there. Unless you guys have any questions, just pop them in and I'll usually see them. I got 2 chat screens to look at, so I'll do my best. Number 8, Section 8. Since the end of the injunction, I am told RCMP enforcement and presence has declined. Meanwhile, some protesters have created new camps, called for reinforcements, and restricted access to the area for the RCMP and Teal Cedar employees and contractors. So, this is like... It's another one of those lines that's like kind of bullshit. Because it's like... The injunction order, the interim extension of the injunction was terminated. So, naturally, RCMP enforcement and presence has declined. This is like to be expected. Meanwhile, protesters have created new camps and called for reinforcements and restricted access to the area for RCMP and Teal Cedar employees and contractors. Yeah. Like, it wasn't the end of the conflict, so people weren't going to go home. It was the end of the injunction. So, like, using this as evidence just feels... I don't know what the word is, but... Yeah, it's like you let the injunction expire, and then, oh my god, people showed up. We better reapply the injunction. But, like, what other outcome was there? You know? It's kind of a failure on the court in that regard, of even letting the injunction expire. Like, I know we obviously wanted it to, but it's just kind of laughable on its face. Again, Stromberg-Stein, if you're out there watching, please, my DMs are open. I would love to talk more. Section 9. Teal Cedar now applies for an interim stay of execution of Justice Thompson's September 28, 2021 order ending the interim extension of the injunction. Ending the interim extension of the injunction. For the reasons that follow, I would grant an interim stay. Okay. On to relevant law. Pursuant to Section 18 of the Court of Appeal Act, yada yada yada, a justice may stall may stall all or part of any proceedings. Section 10(2)(b) provides that a justice may make an interim order to prevent prejudice to any person. So that's like outlining her powers in this role. All right. The test for a stay is the same as the test for an interlocutory injunction. It is the three-part test set out in RJR McDonald v. Canada. The applicant must demonstrate there is some merit to the appeal. The applicant will suffer irreparable harm if the stay is not granted. And 3, the balance of convenience favors granting the stay. We're gonna get into this. I have reading on this that we're gonna talk about shortly. To those on Instagram, I'm live on Twitch where you can see the injunction and see my screen while I'm going through this. I would recommend watching there. Okay. Section 12. The overarching consideration is the interest of justice. Is that a law? Like, that seems like a subjective thing to put into relevant law. Maybe I'm wrong. Section 13. The first criterion is modified when the appeal is from a discretionary order. The applicant must demonstrate that the judge erred in principle. The order is not supported by the evidence. It appears that the order will result in an injustice, or the judge's decision was clearly wrong. Quotes. So the first criterion is modified when the appeal is from a discretionary order. The applicant must demonstrate the judge erred in principle. It's pure the order will result in injustice, or the judge's decision was clearly wrong. I don't fully understand exactly what this refers to, whether it's the first criterion. Are they referring to there is merit to the appeal? Or are they referring to Section 10 of the relevant law section? Anyone with knowledge, I would love to hear more about that. Okay. Stay of execution. Okay, so I think here we're going to jump to RJR McDonald, and we're going to talk about the three-part test. Okay. Okay. The three-part American cyanamide test adopted in Canada and Manitoba Attorney General v. Metropolitan Stores Limited should be applied to applications for interlocutory injunctions as well as for stays in both private law and charter cases. So what I'm reading now is from RJR McDonald from the case of the three-part test. Like this is the decision itself, or part of the written decision. This isn't like writing about it. This is just word for word. At the first stage, an applicant for an interlocutory relief in a charter case must demonstrate a serious question to be tried. Whether the test has been satisfied should be determined by a motions judge on the basis of common sense and an extremely limited review of the case on the merits. The fact that an appellate court has granted leave in the main action is, of course, a relevant and weighty consideration, as is any judgment on the merits which has been rendered, although neither is necessarily conclusive of the matter. A motions court should only go beyond a preliminary investigation into the merits when the result of the interlocutory motion will in effect amount to a final determination of the action, or when the constitutionality of a challenged statute can be determined as a pure question of law. Run-on sentence much. Instances of this sort will be exceedingly rare. Unless the case on the merits is frivolous or vexatious, or the constitutionality of the statute is a pure question of law, a judge on a motion for relief must, as a general rule, consider the second and third stages of the Metropolitan Stores test. So, someone more versed in legalese should really read this and pipe up in the comments with like a better summary of like how this relates, because I'm like not equipped to do it. I'm just not. I'm just gonna skim through it again. This doesn't sound to be true. I mean, whether the test has been satisfied should be determined by a motions judge on the basis of common sense and an extremely limited review of the case on the merits. Yeah, I think we can just base it off that. And I said this is my previous stream, is like, is there merit to the appeal? Yes. People are blockading the road, preventing Teal Jones from doing work. Is there merit to their appeal? Like, yes. I don't think any of us can deny that. Like, Section 2. The applicant will suffer irreparable harm if the stay is not granted. Let's see what Section 2 is. At the second stage, the applicant is required to demonstrate that irreparable harm will result if the relief is not granted. Irreparable refers to the nature of the harm rather than its magnitude. In charter cases, even quantifiable financial loss relied upon by an applicant may be considered irreparable harm so long as it is unclear that such loss could be recovered at the time of a decision on the merits. Oh, that sucks. So I argued this in the last stream, talking about magnitude, because Teal Jones is a large company. They have a lot. Their operations are huge. These few little cut blocks on TFL 46 are like a pittance for them. Like, yeah, they have value. There are millions of dollars worth of timber there. But yeah, I was just kind of like, how could this be irreparable? This is not like, it's not like this is their sole operation. We're not putting a company out of business. You know what I mean? But yeah, they kind of say like it doesn't, the nature of the harm rather than its magnitude. So in charter cases, even quantifiable financial loss relied upon by an applicant may be considered irreparable harm so long as it is unclear that such loss could be recovered at the time of a decision on the merits. So yeah, given reading that, I can see how they would satisfy irreparable harm, because their losses wouldn't be recoverable immediately on a decision. You know what I mean? Like, they've already been delayed so long in the last year that recovery would not be possible immediately. All right. The balance of convenience favors granting the stay. Let's go check out part 3. The third branch of the test, requiring an assessment of the balance of inconvenience to the parties, will normally determine the result in applications involving charter rights. A consideration of the public interest must be taken into account in assessing the inconvenience which it is alleged will be suffered by both parties. These public interest considerations will carry less weight in exemption cases than in suspension cases. When the nature and declared purpose of the legislation is to promote the public interest, a motions court should not be concerned whether the legislation has in fact this effect. It must be assumed to do so. In order to overcome the assumed benefit to the public interest arising from the continued application of the legislation, the applicant who relies on the public interest must demonstrate that the suspension of the legislation would itself provide a public benefit. Okay. Let's read through that again. Again, if you're on Instagram, the full package is on Twitch. The link is in my bio. And you can see my screen as I'm going through this. Okay, let's read the third part again. The third branch of the test, requiring an assessment of the balance of inconvenience to the parties, will normally determine the result in applications involving charter rights. A consideration of the public interest must be taken into account in assessing the inconvenience which it is alleged will be suffered by both parties. These public interest considerations will carry less weight in exemption cases than in suspension cases. I don't know the difference between an exemption case and a suspension case, and I would love to know for this purpose. When the nature and declared purpose of legislation is to promote the public interest, a motions court should not be concerned whether the legislation has in fact this effect. It must be assumed to do so. Sorry, when the nature and declared purpose of legislation is to promote the public interest, a motions court should not be concerned with whether it has the effect. It must be assumed to do so. Okay. In order to overcome the assumed benefit to the public interest arising from the continued application of the legislation, the applicant who relies on the public interest must demonstrate that the suspension of the legislation would itself provide a public benefit. So, the optimist in me looks at that last line and feels like that's an open door. The applicant who relies on the public interest must demonstrate the suspension of the legislation would itself provide a public benefit. There's no doubt that, our side would argue, is relying on public interest. Again, I'm not a lawyer. I don't speak legalese. I'm just going through this with you guys. But I do know Elizabeth Strayed, and she's very busy. But someday I'd love to just talk to her about all this. So, how does he sum it up, or she? The overarching consideration, the balance of convenience favors granting the stay. The balance of convenience favors granting the stay. The balance of inconvenience to the parties. So let's assume public interest considerations carry less weight in this case. I mean, we're going to go through the rest of the document, but I don't... Let's see if Stromberg-Stein said anything about public interest. Yeah, I don't really have anything to say particularly on her decision for Section 3, the balance of convenience favors granting the stay, after reading the full RJR text. But I'm going to keep this in my mind and come back to it. Okay, back to the appeal. Section 12, 13, we've done. Okay, stay of execution. Section 14. With respect to the merits of the appeal, Teal Cedar has outlined 7 grounds of appeal. I really wish I brought up the written appeal because I thought it was laughable. Some of the grounds. With respect to the merits of the appeal, Teal Cedar has outlined 7 grounds of appeal. These can be sorted into 2 overarching issues. First, whether an applicant must establish an enforcement gap to succeed in an application for injunctive relief. Second, whether or to what degree it is acceptable to weigh concerns about the court's reputation when considering the balance of convenience in such an application. Jurisprudence would benefit from having this court weigh in on these questions. Like their grounds, like there were like 2 or 3 of the grounds that were legit. Some of them were bogus. Like, why is the Teal Cedar lawyer arguing that police should be allowed to cover up their name tags for fear of, being targeted, as has been demonstrated in this court previously? And it's like, I'm sorry, did someone get made fun of? Like, did someone have their name and like made them feel insecure, and now all officers get to hide their identities? Like, why is Teal Cedar arguing that? It's not their it's not their it's not their responsibility, for one. It's the RCMP's. And 2, I prefer not to live in a police state with anonymous officers brutalizing people. I don't know. That's just me. But that was one of them. I really should have brought it up just to go through it and have a good chuckle. But yeah, I mean, like I said earlier, with there's some merit to the appeal part of the 3-part decision. Like, there isn't really anything to disagree with on their merit. Like, they're being denied access to a place where they have a license to log. Like, they have merit to the appeal. They can submit whatever. Like, it's pretty factual. Like, there's no arguing that they don't have merit. They do. Okay. 15. Regarding irreparable harm, the blockades erected by the protesters have had and continue to have a significant and detrimental economic impact on Teal Cedar's operations. Teal Cedar has had difficulty undertaking its typical logging activity, which in turn has led to a potential loss of clients and degradation of its reputation. The inability to winterize logging roads, potential unemployment, and permanent loss of workers. Economic harm to First Nations partners, which receive a stumpage fee, the wasting of felled timber, and similar impacts on its contractors. Teal Cedar has also incurred security costs and costs associated with vandalism. The injunction is aimed directly at those protesters engaging in unlawful activities. Contrary to the protesters' submissions, the inability to do so in the presence of an injunction is not irreparable harm. This one's just kind of like, you gotta be fucking kidding me. The more I read that, I remember being shocked when I read this the first time. God, it just like irritates me. Look at that. Look at all of this Teal Cedar. Look at this. Look at all those words. Look at that whole thing. And look at this. All she has is this this denial, this negative line that like did anyone even get to like submit documents? Like, did anyone from RFS's lawyers like did they get to have anything be heard by this judge before this decision? Contrary to the protesters' submissions, the inability to do so in the presence of an injunction is not irreparable harm. Alright, I'm just going to go through this. I'll try not to get heated. Yeah. Okay. Irreparable harm. Yes, I concede that by the definition in RJR McDonald, yeah, this would be irreparable harm because they can't recover it immediately upon the decision of the court. Difficulty undertaking its typical logging activity, which in turn has led to a potential loss of clients. And okay, if you think degradation of its reputation was from like not supplying wood in an efficient manner, then I think you kind of haven't been paying attention. The inability to winterize logging roads, like, Roads that are already built, if they get washed out or anything, like, it's not that difficult to repair them. You know, like, we've seen how quickly excavators can, like, make a road. If it's not like blasting and making new roads, this isn't really like something to write home about. Potential unemployment and permanent loss of workers. Economic harm to their First Nations partners, which receive a stumpage fee. Yes. The wasting of felled timber. If you knew how much waste logging in BC, logging on the island, logging on the south coast, how much waste there is, this is laughable. But of course, this is considering, trees that were going to be put onto trucks and shipped away. But like, to anyone who's actually been in a clear cut and seen what's left behind, the notion that that wasting timber is like a loss to them is a joke. Teal also incurred security costs and costs associated with vandalism. I'm very curious what vandalism there has been. The injunction is aimed directly at those protesters engaged in unlawful activities. So, here's another one where this doesn't really make any sense, because everyone on the road has been doing something unlawful by blocking the road. Every single person. You can be there, but like the second you, like, did you help build a soft block? Did you build a hard block? Did you carry some concrete one time? Like, literally everyone is doing something unlawful there. Like, it's like trying to create this division between the protesters to say that there is a good, peaceful way to protest. You know what I mean? It's like this injunction is targeted at the unlawful ones. It's like, no, they're all unlawful. Like, you will not create this fake division. And of course, do the RCMP care? Do the RCMP make a distinction? No, they just arrest everybody. They arrest media. They pretty much dredge the protesters into a pen and just arrest everyone. And this fucking line. The injunction is aimed directly at those protesters engaging in unlawful activities, and contrary to the protesters' submissions, the inability to do so in the presence of an injunction is not irreparable harm. Like, what a joke. This injunction is targeted to the ones engaged in unlawful activities like... Oh, she doesn't actually specify. The injunction is aimed at them directly. And their inability to perform those unlawful actions in the presence of an injunction is not irreparable harm. Like, what gymnastics did she have to jump through to, like, consider that fair in her judgment? Ugh, this is gross. I don't feel like she really did her job. And for Section 3 or Section 2, the applicant will suffer irreparable harm if the stay is not granted. Like, she's supposed to... Isn't she supposed to do both? Second stage, I'm charged with irreparable harm. Oh, a balance of convenience is where they have to consider both. Okay, Section 16. I'll cool down. Lastly, the balance of convenience in this instance lies with Teal Cedar. When considering a stay of execution, this court strives to preserve the status quo. Here, the status quo is Teal Cedar engaging in government authorized legal activity unobstructed by lawful actions. The status quo is the long standing injunction. No matter how unsavory the protesters find Teal Cedar's logging, their quarrel is with government policy. Good fucking Lord. To those on Instagram, I'm on Twitch. The link is in my bio. I'm just doing this on IG because that's where all my followers are. But on Twitch, you can see my screen and the decision that I'm going through. And I'm also recording, so it will be uploaded later. Okay. Section 16. Oh. So triggering. The balance of convenience in this instance lies with Teal Cedar. Like, okay, well, hear you out. When considering a stay of execution, this court strives to preserve the status quo. Like, let that one just sink in for a minute. When considering a stay of execution, this court strives to preserve the status quo. Like, we know what colonial institutions preserve. I, as a member of the media, understand what Canada's media institutions preserve. They all preserve the status quo. And the court just says it. When considering a stay of execution, this court strives to preserve the status quo. Strives to preserve. The status quo can be unethical, can be unlawful, can be illegal, can be racist, can be unjust. This court strives to preserve the status quo. I don't know. I don't even need to go into that. What's up, Colin? Yeah, we know what that means. Here, that status quo is Teal Cedar engaging in a government-authorized legal activity unobstructed by unlawful actions. Yeah. So, I think what we all want to know is how far is the court and the RCMP willing to go to unobstruct Teal Cedar's lawful actions. Like, we've seen what they can do. And the court, like in Stromberg-Stein's opinion, strives to preserve it. Yeah. Like, it's just right there. I love it when it's so obvious. Like, it's from the judge herself. Like, it's not, us talking shit about them. Oh, the status quo is the long-standing injunction. Yes, I don't disagree with you. No matter how unsavory the protesters find Teal Cedar's logging, their quarrels with government policy. This is another one where balance of convenience, they even specify in RJR, where is it? Third part of the test. A consideration of public interest must be taken into account in assessing the inconvenience which it is to alleged will be suffered by both parties. There, it's right there in RJR, which she cites in her decision making for the injunction, which is like the basis for most injunctions, but I just want to bring it up because she's using it and leaning on it. The balance of convenience. Does she say anywhere in 16 that she is considered the public interest? Nowhere. Nowhere in 16 at all. Her only line no matter how unsavory the protesters find Teal Cedar's logging, their quarrels with government policy. This should read the public. Like, she legally needs to consider the public interest. That is part of the third part of the three-part test. And here she is. No matter how unsavory the protesters find Teal Cedar's logging, their quarrels with government policy. So, on the merits, you can't really argue. Like, the merits are there. Regarding irreparable harm, yeah, based on the wording of it in RJR, yeah. Unfortunately, it doesn't have to do with the magnitude, it's the nature of the harm. But the third part, the balance of convenience, she just fucking ignores it. She doesn't consider public interest. She doesn't really give, protesters any thought. Which, whatever. You wouldn't expect her to, but... Ugh! Never thought I'd get hot reading legal documents. Okay. Section 17. There is a stark difference between peaceful protest and unlawful and dangerous interference. The issue here is a serious concern for public safety, since the refusal of Justice Thompson to extend the injunction. Issuing a stay would revive the injunction of Justice Verhoeven as modified by Justice Thompson, thus enjoining this unlawful activity. So I had to look up what enjoining meant. So enjoining, it has two meanings. One is to forbid something, and one is to bring two things together. So I'm pretty sure how she's using it here is, where are we? The issue here is a serious concern for public safety since refusal of issuing a stay would revive the injunction, thus enjoining this unlawful activity. The protests were already unlawful. The protests were always unlawful. There is no stark difference between peaceful protests and unlawful and dangerous interference. The protests have only been unlawful and dangerous interference because they've been standing in the way of excavators. The protests have not been peaceful, or have not been what this court would define as peaceful protests, as standing politely on the side of the road with a sign. That is what the courts would deem peaceful protest. We would call it something different, but really need to hammer home that, it's all unlawful. So issuing a stay would revive the injunction of Justice Verhoeven as modified by Thompson, thus enjoining the unlawful activity. To those who just joined, I'm on Twitch, where you can see my screen as I'm going through the documents. But I will be uploading the live version on Instagram as well as the full version on Twitch. Welcome. Okay. In a situation where the criminal law has not been effective, it is in the interests of justice to grant this interim stay to prevent serious prejudice to Teal Cedar. This is an urgent matter, especially in light of the upcoming long weekend, which I have been told may bring the potential for a surge in numbers of protesters. For one, I want to know who has the ear of this judge and why is she bringing, hearsay? Is it not hearsay if it comes from a judge? I don't know. It just frustrates me to see her bringing herself into this. I'm gonna like hit my limit for legal documents. Okay, there's I do want to touch on this part, section 17. In a situation where the criminal law has not been effective, it is in the interest of justice to grant this interim stay to prevent serious prejudice to Teal Cedar. In a situation where the criminal law has not been effective, it is in the interest of justice to grant this interim stay to prevent serious prejudice to Teal Cedar. So let's just talk about this. In a situation where the criminal law has not been effective, we're going to reapply the criminal law that hasn't been effective. In a situation where criminal law has not been effective, grant this interim stay to prevent serious prejudice to Teal Cedar. How are you going to prevent serious prejudice to Teal Cedar with a criminal law that has been shown to be demonstrably ineffective? Like, what?
Because the injunction is separate from criminal law. It's civil law, isn't it? Isn't that the point that you made? Sorry.
It's all right. My partner's interrupting the stream to ask me a question I don't know how to answer. But she was asking if it had to do with civil versus criminal law, which you can receive criminal charges in civil disputes, which is what the injunction is. The injunction just provides a legal basis to enforce a civil dispute for like the state to step in via RCMP. Sorry, criminal law. Freaking, she ruined my flow. I gotta move on. I could be mad about this line about criminal law not being effective forever, and the fact that she's like, I heard there's gonna be lots of protesters on the long weekend. We're just gonna move past to save myself. All right, disposition, section 18. I would stay the execution of Justice Thompson's order pronounced September 28th, 2021, pending judgment on the application for leave to appeal and the appeal. Okay. The application for leave to appeal will be heard with the appeal. Okay. All parties have indicated they are available for the matter to proceed on November 15th, 2021. I will ask the registry to set aside November 16th as well. Do the parties need any assistance with timelines for filling the materials? Materials should be filed 1 week in advance of hearing. Ta-da! Okay. Well, there you go. I should really write. I'm going to write something about this. Actually, I have I have too many things to write. I still have to write my Charney piece. But I could make like infographics about some of this stuff, like the criminal law has not been effective line. There's a couple more. She doesn't consider the public interest at all. I could just do a problems with the appeal decision. Little infographic. You guys have any questions? This is going to be posted for people to share. Whew. I like walk this off. I just feel like gross. I'm done reading, so if you guys have anything you want to say or ask. Also, hello trombone. Yeah, so I guess you came in late. The mandate for including public interest. So if anyone's on Twitch, you can see this. Where are we going? Under the... No, I'll explain. And watch this on Twitch later, and you can see me I don't want to use Marmar in the real world. I know. I know who you are. Um, so under relevant law in the appeal decision section 11, um, the test for a stay, being a stay in the injunction, is the same as the test for an interlocutory injunction. It is the three-part test set on RJR McDonald v. Canada, Attorney General bracket 1994. As a three-part test, one, there is some merit to the appeal. Two, the applicant will suffer irreparable harm if the stay is not granted. And three, the balance of convenience favors granting the stay. So I read through RJR McDonald, and I read the full wording for the three-part tests. And this is what's like, it looks like the three-part test is used in most injunctions in Canada. So it's kind of good to know now. So the third branch of the test, so the third part is what? The balance of convenience favors granting the stay. And here's the original wording. The third branch of the test, requiring an assessment of the balance of inconvenience to the parties, will normally determine the result in applications involving charter rights. And here's the line, Marmar. A consideration of the public interest must be taken into account in assessing the inconvenience which it is alleged will be suffered by both parties. It's right there, like flat out. It does say more than that, like, I don't understand, where it says, these public interest considerations will carry less weight in exemption cases than in suspension cases. I don't know the difference between an exemption case and a suspension case. And there's a bunch more legalese on how to interpret like public interest, and I don't know how to interpret it in regards to Fairy Creek. I don't know. I am gonna like put something together on like the problems of the appeal decision. Because it's worth talking about. And I think, like, yeah, colonial systems are fucked. Colonial courts are fucked. We shouldn't rely on them. But, like, if there's one thing I've learned very recently from some wisdom that some elders have shared with me, which is to do battle on all fronts. To be on the street, to be in the courts, to be, meeting with, stakeholders privately, negotiating, litigating, to basically be trying to do all things at once and with the same energy. I'm kind of butchering the lessons that were taught to me. But yeah, I think it's important to understand because, like, regardless of what we think of these courts, they are still, like, what everyone else, holds weight in and, like, has power over. You know what I mean? Like, everyone else still respects the courts. And being able to point out flaws in the courts within their system is probably more helpful and more revolutionary than convincing someone that, like, colonialism is bad and still exists and you should be a communist. You know what I mean? Yeah. %, Marmar. Yeah, Marmar, we ever meet up in person again, I would love to tell you about, just where I've been, the time I've had. It's been, like, transformative for me. Okay, I'm gonna sign off and get these ready to upload. Thank you for watching, and yeah, feel free to share these widely because I don't think anyone's really done this, and I hope this fills a gap for people and helps people kind of break in. Yeah, Mara. I'm in Vancouver. You got my number. I don't know if where you live, but yeah, let's connect. Okay. Um, bye, folks. Love y'all.